the Honorable, the Presiding Associate Justice, and the Associate Justices of the Supreme Court of the Philippines. Hear ye, hear ye, hear ye. All persons having business before the Honorable Supreme Court of the Philippines shall give their attention, for the Court is now in session.
Declare court ready the case.
Your Honors, good afternoon. For today's oral argument are the consolidated cases docketed as GR number 208912, entitled Amadea Angela Aquino, petitioner, versus Rodolfo Aquino and Abdulah Aquino, respondents, and GR number 209018, Rodolfo Aquino as petitioner versus Amadea Angela Aquino as respondent.
Appearances for the parties, please.
The appearances, Your Honors. Counsel for petitioners, Attorney Charles Anastasio. Counsel for Amadea Angela Aquino in both cases. Please remain standing, please. Attorney Anastasio, please rise. Just remain standing. Attorney Leilani Yang Espejo. Counsel for Rodolfo Aquino in both cases. Attorney Geraldine Kimosing Chiu. Counsel for Respondent Abdulah Aquino in GR 208912. For the Office of the Solicitor General, Solicitor General Jose Calida. Assistant Solicitor General Marisa de la Cruz Galandines. Assistant Solicitor General Bernard G. Hernandez. Assistant Solicitor General Rex Bernardo Pascual. Assistant Solicitor General Marisa Macaray Gillian. And Assistant Solicitor General Gilbert Medrano. For the Amici Corps, Your Honors, we have Dean Cynthia Del Castillo and Professor Elizabeth Aguiling Pangalanan.
Okay, please take your seats, please.
You may
Now, the counsel of Amadea Angela Aquino is given 10 minutes to present its stand. There are two counsels here. Who will be the counsel who will make the opening statement? You will be the one? Okay. And then after the presentation of the counsel of Amadea Aquino, then the counsel of both Rodolfo Aquino and Abdulah Aquino will be also given 10 minutes to present your stand. Then the Office of the Solicitor General, 10 minutes. In the course of the interpellation by the members of the court, the amici curiae may be asked to answer some questions from the members of the court. Okay, are you ready, counsel? Okay, please proceed.
Good afternoon, Your Honors. I am Attorney Charles Anastasio, respectfully appearing for the petitioner in GR number 208912. We are ready, Your Honor. May it please the Honorable Court. The basic substantive issue to be resolved in this case is whether or not Amadea Angela K. Aquino, petitioner in GR number 208912. The natural child of a legitimate son can inherit by right of representation to the estate of her father's deceased father. Petitioner respectfully submits that the answer to this issue is yes. Corollarily, the issue is whether or not the Iron Curtain rule would apply to defeat such right, and petitioner respectfully submits that this issue should be resolved in the negative. Likewise, as pointed out by the Honorable Court, the full resolution of the instant case would necessarily require tackling the issue of whether or not petitioner is already barred from claiming filiation. To this, petitioner humbly submits that she is not. Petitioner likewise respectfully submits that petitioner may raise the issue of filiation in a settlement proceeding. It is petitioner's submission that among the settlement court's power is the determination of the status of the heirs in order to fully and properly distribute the estate of the deceased. It is petitioner's position that respondents are stopped from assailing her filiation with her deceased father and grandfather pursuant to respondents' own admissions, declarations in their pleadings submitted before the lower courts. Furthermore, petitioner submits that it is high time that the Honorable Court declare Article 992 of the Civil Code as unconstitutional for being violative of the Equal Protection Clause. In the alternative, petitioner submits that if such provision be maintained as constitutional, this Honorable Court include grandparents, as the present interpretation does not actually serve the purpose and spirit of the said provision. Let us not apply the letter of the law that kills, but rather the spirit of the law that gives life. In sum, petitioner respectfully submits that the hearing appeal decision of the Honorable Court of Appeals is erroneous and should be reversed. May I now address the issues, Your Honor? The first procedural issue is whether or not Amadea Angela K. Aquino is barred from establishing her filiation to Arturo C. Aquino for failing to file the claim within 4 years from attaining the age of majority. Petitioner respectfully submits a negative reply. The two exceptions provided under Article 285 do not apply, as they have been omitted by Articles 172, 173, and 175 of the Family Code on proof of filiation. Article 173 provides the action to claim legitimacy may be brought by the child during his or her lifetime and shall be transmitted to the heirs should the child die during minority or in a state of insanity. In these cases, the heirs shall have a period of 5 years within which to institute the action. The action already commenced by the child shall survive notwithstanding the death of either or both of the parties. The second procedural issue is whether or not Amadea Angela K. Aquino's claim of filiation through a motion to be included in the distribution and partition of the estate is appropriate in an estate proceeding. An affirmative reply is respectfully submitted, conformably with the ruling in Ramela, Saldarriaga, etc., petitioner, Apelli versus Enrique E. F. Marino, where, I quote, "Upon the other hand, it is well settled that the matter of acknowledgement of an alleged natural child and his claim as such to a share in the estate of the alleged natural father may be determined either in an ordinary civil action or in special proceedings for the settlement of the estate of the deceased father." Substantive issues. Whether or not Andrea Angela K. Aquino is a legally recognized illegitimate child of Arturo C. Aquino. A, whether or not Amadea Angela K. Aquino can be allowed to prove her claim of illegitimate filiation to Arturo C. Aquino after his death in accordance with the provisions of the Civil Code and or the Family Code. And B, whether or not Rodolfo C. Aquino and Abdulah C. Aquino are stopped from questioning Amadea Angela K. Aquino's filiation. I, whether or not the Aquino clan's overt acts translate to legal recognition of Amadea Angela K. Aquino's status as Arturo C. Aquino's child. This time, an affirmative reply to each of these issues is respectfully submitted. Petitioner can be allowed to prove her claim of illegitimate filiation to Arturo C. Aquino after his death. The ways of proving filiation are provided under Articles 172 and 175 of the Family Code, which read as follows. Article 172, the filiation of legitimate children is established by any of the following. Okay? 1, the record of births appearing in the civil register or a final judgment. Or 2, an admission of legitimate filiation in a public document or a private handwritten instrument and signed by the parent concerned. In the absence of the foregoing evidence, the legitimate filiation shall be proved by 1, the open and continuous possession of the status of a legitimate child, or 2, any other means allowed by the rules of court and special laws. Article 175 says that illegitimate children may establish their illegitimate filiation in the same way and on the same evidence as legitimate children. Petitioner concedes that she cannot establish the proof required under Article 175 in conjunction with paragraphs 1, 2, and 3 of Article 172. This is just impossible for her to do so, since she was born on October 9, 1978, or around 9 months after her father died. Her father, Arturo, died on January 10, 1978. There cannot be a record of birth or an admission by the parent concerned or open and continuous possession of the status of an illegitimate child. However, her filiation to her father Arturo can be, and in fact had been, proved by, quote, other means allowed by the rules of court and special laws. The records show that under date of July 2, 2003, petitioner filed in special proceedings number 6972-2003 her motion to be included in the distribution and partition of the estate, where she alleged, among others, that it was Arturo Aquino's family, particularly his father, Miguel Aquino, who provided for the medical expenses of the yet unborn child of his son. Immediately after she was born, petitioner and her mother, Susan Kwan, lived with the Aquino family at their ancestral home. One of the godparents in the baptism of petitioner was Abdulah Aquino, brother of her father, Arturo Aquino. From the time of her birth until the present, petitioner has been recognized by the Aquino clan as the natural child of Arturo Aquino. Miguel Aquino, the grandfather, supported herein petitioner from her birth and spent for her education from the kinder level to college. Miguel Aquino, the deceased, gave a parcel of commercial lot to the herein petitioner. The employees of the Aquino clan also know herein petitioner to be a member of the Aquino family. These allegations set forth in petitioner's motion to be included in the distribution and partition of the estate were all admitted by respondent Abdulah Aquino in his comment to the petition dated November 14, 2003. And no less significant are the admissions made by respondent Abdulah Aquino in his submission with motion for approval of partial partition filed in special proceedings number 6972-2003, where he stated that the partial partition covers the properties given by Miguel Aquino to his heirs by virtue of his dying instructions dictated on his deathbed on 2 July 1999. The partial partition and the written instruction above both provide that the lot in front of Linda T. Aquino's residence along Volcan Street.
Counsel, may I interrupt you?
Yes,
Your time is up. Can you wind up?
I'm sorry?
Your time is up. You are only given 10 minutes.
Oh, all right, Your Honor.
Okay. So who will interpolate? You will first. Okay. Justice Lunen will first interpolate. Go ahead.
Good afternoon, Counsel.
Good afternoon, Your Honor.
By the way, is the petitioner present in the session hall?
I'm sorry, Your Honor?
Is the petitioner present in the session hall?
Yes, she is, Your Honor.
Can she please stand up so we can recognize her? Okay,
She's now standing up, Your Honor.
okay, thank you. Thank you, Ms. Amadea, thank you. You can take your seat. Is she actually a resident of the Republic of the Philippines for now?
As of now, I understand that she is living in the U.S., in the United States.
In the United States. So in a lot of the pleadings so far that we saw in the Rollo, there was an allegation that upon the death of her grandfather, that she lived for a while in the ancestral home of the respondents. Is this true?
Yes. Yes, Your Honor.
Would you know how many years after the death of the grandfather, this is Miguel, in 1999, did she live with the respondents?
My understanding is that she lived there for about 2 years, Your Honor.
She lived with them for about
2 years, Your Honor.
Okay, thank you. Are you an illegitimate child yourself, Counsel?
I'm not, Your Honor.
You're not, yes. But for illegitimate children, there is an adjective called illegitimate.
I'm sorry, Your Honor.
For children who are born out of wedlock,
They
the
are
law
called-
gives them the adjective illegitimate.
Yes, Your Honor.
Are they illegitimate about?
What is it about?
Why are they illegitimate? Why are the children
Because they were
illegitimate?
born out of lawful wedlock, Your Honor, please.
But it is not them that caused the defect, correct?
Yes, Your Honor. Yes.
It is the parents, correct?
As I understand, yes, Your Honor.
So should it be that the parents be called the illegitimate parents rather than the child? Because the child bears the appellation or the label for life. Is that not correct?
Yes, Your Honor.
Yes. And can a child does a child have a control as to who her parents are?
Definitely not, Your Honor.
They could not.
They
Do
cannot.
they choose how they were produced?
They cannot, Your Honor.
They cannot. Do they choose to whom they would belong to as soon as they are born?
At the moment they're born, I suppose they could not.
In other words, the status of being illegitimate, quote unquote, is something beyond the control of the child. Is that not correct?
Yes, Your Honor, please.
It is like the color of one's skin. Is that not correct?
Yes, Your Honor.
And, do we discriminate on the basis of the color of our skin?
Do we discriminate, Your Honor? I'm sorry, Your Honor, I didn't.
Do we discriminate on the basis of the color of our skin?
No, Your Honor.
We cannot, right?
Yes.
Whether the color of your skin is white or black, it is a basis of burdens which is clearly unconstitutional. Is that not correct?
Yes, Your Honor.
Not only is it unconstitutional, but just because you do not choose the color of your skin, you do not have any agency to choose the color of your skin, similar to you do not have control of how you were born, who your parents are, then certainly the burden given to you by law should be something which is, against others, clearly discriminatory. Is that not correct?
Yes, Your Honor.
Okay. Just to understand the circumstances of your petitioner, first, let us just go through the family tree, just so everyone understands. Amadea is born of Arturo Aquino and Susan Kwan. Is that not correct?
Yes, Your Honor.
And as we go through it, there is a slide presentation that my staff did in order that all of us in the courtroom can understand. So Arturo Aquino and Susan Kwan begot Amadea Angela Aquino, who was born on October 9, 1978. Is that
Yes.
not correct?
Yes, Your Honor.
So it's October of 1978. Is that not correct?
Yes, Your Honor.
Yes. And Arturo, on the other hand, died not seeing his daughter on January 10, 1978. Is that true?
Yes, Your Honor.
In other words, upon the birth of Angela Aquino, she never met her father. Is that not correct?
That's right.
Yes. And they were born on the same year. Is that not correct?
Yes, Your Honor.
We will refer back to this when we go back to several questions regarding filiation and the ability of Amadea Angela Aquino to prove filiation upon the death of her father. Is that not correct?
Yes, Your Honor.
Yes. So Amadea could not have, by herself, immediately upon being born, prove during the lifetime of the father her filiation. Is that not correct?
That's right, Your Honor.
Because this is a case which seems to be unique. It is impossible, correct?
Yes, Your Honor.
To be able to prove it during the lifetime of the father simply because the father predeceased Amadea. Is that not correct?
Yes, Your Honor.
Now, let us look at the months of birth of the month of birth of Amadea. It is October of 1978. Is
Yes,
that
Your
not
Honor.
correct? And the death of the father is January of
January.
1978. Is that not correct?
Yes, Your Honor, please.
How far apart is this, counsel?
That's about approximately 9 months, Your Honor, please.
So is it possible still to have Amadea being born of Arturo when it is almost precisely 9 months?
It is possible, Your Honor, please.
You mean to say that there can be a child born after more than 9 months from the womb of the mother? Is that biologically possible?
I'm not sure about that, Your Honor.
So you concede that there is some doubt as to whether or not your client is the daughter of the father.
No, I don't, as far as I'm concerned, Your Honor.
So again, I ask you the question, is it possible to carry in the womb of a woman a child more than 9 months?
To my limited knowledge, no, Your Honor.
You just gave away the case of your client.
I'm sorry.
You just gave away the case of your client.
I'm
You are conceding that it is impossible to be born after more than 9
Your
months.
Honor, I'm just saying that my limited knowledge does not allow me to answer that question, Your Honor.
Oh, you should have.
I'm not conceding anything, and I'm not giving up the case for my client. Your
I
Honor.
think, counsel, you should have done your research. It was very clear in the pleadings that the father of your client was died on January 10, 1978,
I'm
and
aware
your
of that.
client was born on October 9. Just doing the mathematics, and the normal knowledge is that 9 months in the womb of a parent, and thereafter the child is born. Again, can I ask you, would you know if it is possible to carry the child in the womb of the mother for more than 9 months?
I'll be honest with the court, Your Honor.
Would you like to
understand.
consult with your client first?
I'm sorry,
Would you like to consult with your client?
if you will allow us.
Yes. Kindly have a few seconds. Thank you. Hindi pa. I'll ask. Are you prepared to answer my question?
Your Honor, can be.
It can be, okay. Is the mother still alive?
So,
Is the mother of your client still alive?
yes, Your Honor, please.
Is she present in the
She
courtroom?
is in court, Your Honor.
Can I ask the mother to please stand up?
Oh, I'm sorry, I was misinformed. I was introduced to a lady earlier
Yes.
Before the hearing, I thought it was the mother of the petitioner.
Yes.
I'm sorry, Your Honor.
You might have mistaken in pointing somebody else as the mother, and that would be very dangerous, correct? Yes, in any case. So the mother would be in the best position to know, but of course, we do not deal with factual questions at this level. But insofar as we are concerned, this is the relationship of Arturo, Susan, and Amadea. Is this not correct?
Yes,
Okay.
Your Honor.
Let's expand it a little. So Mr. Arturo Aquino is the son of Mr. Miguel Aquino and Amadea Aquino. Is this not correct?
Yes, Your Honor.
And Arturo Aquino predeceased the grandfather or the alleged grandfather of Angela Aquino. Is that not correct?
Yes, Your Honor.
And therefore, Miguel Aquino died on July 5, 1999. And therefore, at the time that Angela Aquino was born until 1999, she had the opportunity to have a relationship with her grandfather. Is this not correct?
Yes, Your Honor.
Yes. And Arturo Aquino is not the only offspring of Amadea and Miguel Aquino. Is this not correct?
Yes, Your Honor.
They are actually 4 brothers. Is this correct?
Yes, Your Honor.
Okay, so we have Abdulah, one of the petitioners, respondents, Rodolfo, one of the respondents, Wilfrido C. Aquino, predeceased Arturo, Miguel, which is the grandfather, but by right of representation, there are legitimate descendants of Wilfrido Aquino. Is this not correct?
Yes, Your Honor.
Yes, and we are therefore concentrating now on the relationship of Amadea Angela Aquino, Arturo C. Aquino, and Miguel Aquino. Can we show us the simplified format? Is this correct? Amadea now wants to inherit from Miguel Aquino. Is this not correct?
Yes, Your Honor.
Yes. But if Amadea Aquino were not present, it would be that Arturo Aquino, the line of Arturo Aquino, would not be able to get his legitim. Is this not correct?
I'm sorry, Your Honor. What was the question again, Your Honor?
All the brothers are entitled to a legitim
Yes, Your Honor.
from Miguel. Is this not correct?
Yes, Your Honor.
Yes. But were it not for the presence of Amadea Angela Aquino, because Arturo predeceased Miguel, there would be no legitim that will be given to this line.
Yes, Your Honor.
Correct? And therefore, could we say that to preserve the legitim of Arturo Aquino, given that he has an illegitimate child, it might be possible, or the law can be interpreted, so that Amadea Aquino may be able to inherit from Miguel Aquino. Is this not correct?
Yes, Your Honor.
Yes. So this is not a case about whether Amadea Angela Aquino can inherit from the brothers.
That's
Correct?
right, Your Honor.
This is a case that can be seen as only Amadea Aquino wanting to take by representation the legitim of Arturo Aquino. Is this not correct?
Yes, Your Honor.
Yes. So it is not, it may be directly Amadea Aquino inheriting from Miguel, but it is inheriting by representation. Is this not correct?
Yes, Your Honor.
Yes, okay. Now, let's go to a provision which has become contentious in this controversy. This is Article 992 of the Civil Code.
Yes, Your Honor.
Are you familiar with this article?
Yes, Your Honor.
Yes. The article actually states, if you may, if I may read, an illegitimate child has no right to inherit ab intestato from the legitimate children and relatives of his father or mother, nor shall the children or relatives inherit in the same manner from the illegitimate child. This case is about the first clause. Is this not correct?
Your Honor. Yes, Your Honor.
Yes, the first clause being, an illegitimate child has no right to inherit ab intestato from the legitimate children and relatives of his father or mother.
Yes, Your Honor.
And with respect to the first clause, this has nothing to do with Angela wanting to inherit from the brothers. Is this not correct?
Not from the brother, no.
Yes. So therefore, this is about the interpretation of the provision in relation to relatives of his father or mother. Is
Yes,
this
Your
not
Honor.
correct?
Yes, Your Honor.
Yes. By the way, the petitioner's name is Amadea or Angela. What is the usual name that by which she is called?
The petitioner's name is Amadea Angela, Your Honor.
Yes, how is she usually called?
She is called usually Maggie.
Maggie.
Maggie, Your Honor.
Okay, let's use Maggie for now, so that it is entered into the records, correct? Yes. So this is about the interpretation of relatives of his father or mother. Is that not correct?
Yes, Your Honor.
Yes, and relatives here can refer to collateral relatives or relatives in the ascending and descending line.
Yes,
Is that
Your
not
Honor.
correct?
Yes, Your Honor, please.
Were it not for an actual interpretation in 1987 in the case of Diaz versus Intermediate Appellate Court, it could have only referred to collateral relatives. Is this not correct?
Yes, Your Honor.
You would agree with me that the first case to interpret that it applied to the ascending line was the case of Diaz versus Intermediate Appellate Court.
I'm sorry again, Your Honor, but what was your question?
You would agree with me that the first case that interpreted 992 as applying to the ascending line, meaning to say prohibiting the grandchildren who are illegitimate to inherit from the ascending line, is Diaz versus Intermediate Appellate Court.
Yes, Your Honor.
Yes, that was the first case. As a matter of fact, it was given an importance by this court because it was also orally heard in 1987, correct?
I don't know about that, Your Honor.
Well, it's in the case itself. Would you know? Yes, it was. It was
Okay.
heard by this case in oral arguments with even amicus curiae. Would you recall that?
I recall the case, Your Honor, but I
Yes,
don't
and the
remember.
amicus curiae included Justice Kagiwa. Is that not correct?
Yes, Your Honor.
Among others, JBL Reyes also.
Yes,
Correct?
Your Honor. Yes,
Among
Your Honor.
others, Professor Balane. Is that
Yes,
not
Your
correct?
Honor.
All men. Correct?
Yes, Your Honor.
And in this case, now we hear again the interpretation of 992, but now we have amicus who are all women. Strange. And a development of our society. Is that not correct?
Yes, Your Honor.
Yes, the experts now on this, which are called by the court as amicus, friends of the court, are now experts by themselves, professors in the leading law schools in this country, specifically UP and Ateneo, if I'm not mistaken, and former deans, and one about to be dean at some point. But in any case, so therefore, it was orally heard, correct?
Yes, Your Honor.
So the interpretation that it applies to the ascending line was not introduced clearly in the law, but it was introduced by a case. Is that not correct?
Yes, Your Honor.
Yes. By the way, how do we interpret a provision of law? How do we interpret a provision of law? Can we just pray to God and have enlightenment if there is a God?
You interpret the law as a whole, Your Honor, please,
As a whole.
with justice and fairness as the
Let's set
considerations,
aside
Your Honor.
justice and fairness first, because equity always follows the law. Is that not correct?
Yes, Your Honor.
That is a civil law, it's a canon in interpretation of civil provisions that before equity is the law. Is that not correct?
Yes, Your Honor.
Yes. And of course, the first thing that we need to do is look at a precedent, but if the precedent happens to be 1987, what we can do is always look at the provision of the law in the context of other provisions in the same law. Is that not correct?
Yes, Your Honor.
And of course, after looking at it in the context of the same law, then we can also look at the provision in the context of other statutes which may have been promulgated after the law has been passed. Is that not
Yes,
correct?
Your Honor.
And the statutes that would have been passed should be taken in the interpretation of the current provision like Article 992. If there were statutes that were passed after that, we should take that into consideration because there is only one law. Is that not correct?
Yes, Your Honor.
And every provision of law must be read consistently with all other provisions of the law. Is that not correct?
Yes, Your Honor.
Also, when we interpret the provision of the law, we always have to take into consideration and in mind the provisions of the Constitution, because in the interpretation of the Constitution, the Supreme Court must take care that all fundamental rights are also considered. Is that not correct?
Yes, Your Honor.
And the interpretation of the law even though we do not declare a provision of the law as unconstitutional, still, when we interpret the provision of a law, we should choose an interpretation that avoids a conflict with any of our fundamental rights. Is that not correct?
Yes, Your Honor.
Yes. Now, let us look at the provision of the law itself, 992. Okay, it mentions relatives of his father or mother, correct?
Yes, Your Honor.
Are there provisions relating to succession where it specifically involves the grandparents and grandparents as specifically contained in the text of the Civil Code?
Well, I understand that there is the provision regarding the right of illegitimate descendants to inherit from their grandparents. Your Honor.
Yes, and clearly in those texts, the word grandparent is used, correct?
Yes, Your Honor.
So can we say that if Article 992 really intended to cut any successional rights, then it would have mentioned very clearly grandparents. Is that correct?
Yes, Your Honor.
Is that possible? By the way, is iron curtain a textual provision? That phrase, iron curtain,
Yes, Your Honor.
is that a textual provision?
No, it is not, Your Honor.
It's not. Where did that come from? Because this 992 is often referred to in textbooks as the iron curtain rule. Where did that word iron curtain come from?
I don't know. I'm familiar with Iron Curtain referring to the communist countries, Your Honor, please.
It's in Diaz
Sorry.
versus Intermediate Appellate Court. In that case, which was the seminal case interpreting 992, the ponente introduced the words, the iron curtain, that separates.
All right, Your
Okay, and the reason for that, counsel, would have been, according to Diaz, what was the reason for putting an iron curtain?
So that it can't be breached, Your Honor, please.
So that,
It cannot be breached.
yes, because,
That it should be impregnable, Your Honor.
to prevent animosity between the families. Is this not correct?
Yes, Your Honor.
That's very clear in the text of Diaz versus Intermediate Appellate Court. Yes, okay. Now, would you say that there was animosity among the brothers and Maggie at the time that the grandfather was alive?
Given the facts of the case, as shown by the records, there was no animosity.
There was no animosity after the death of the father and while the grandfather was living. Is this
Yes,
not
Your
correct?
Honor. There was no animosity.
After the grandfather died, was there any animosity?
There was still no animosity, Your Honor.
And is there any animosity now between the brothers and the offspring of Arturo?
As far as I know, none, Your Honor.
Until now, there is no animosity.
Sorry?
So they are all right.
Yes, Your Honor.
So they can compromise this case.
I don't know. They have not come
So
to
that if we
point, Your
mediate
Honor.
this, then we can go home immediately. And I can now attend to, we can now attend to the many other cases filed by the government against the Solicitor General.
That would be best, Your Honor.
And I think he is very busy and he has to work on a lot of things. You do not know. But in any case, during the lifetime of the grandparent, Miguel, there was no animosity. As a matter of fact, according to your pleadings, and it appears to be having been established by the facts, Maggie in fact lived in the ancestral home. Is this not correct?
Yes, Your Honor.
Subject to confirmation later from the counsels for the respondents. Are you sure?
She lived in the ancestral home, Your Honor.
Okay.
That's an admitted fact, Your Honor. Please.
Okay, so in interpreting the provision of the law, we have to look at the textual contents of the other provisions in the same law. Is that not correct?
Yes, Your Honor.
Yes. Now, was there, in 1987, was there a significant event in relation to our constitutional order?
Was there I'm sorry, Your Honor?
A significant event in relation to the constitutional order of the Republic of the Philippines in 1987.
87. I'm not aware, Your Honor.
Wow. In 1987, Counsel? On what year was our Constitution promulgated?
Oh, I'm sorry. 1987.
1987.
Yes,
What
Your
year,
Honor.
Counsel?
Your
What
Honor?
month was our Constitution promulgated in 1987?
Yes, Your Honor.
Yes, what month in 1987?
I'm not so sure, Your Honor. what
Well,
exact number.
it was promulgated in 1987. Diaz was decided in 1987, correct? And was there, in the case of Diaz versus Intermediate Appellate Court, was there anyone that raised the question of equal protection in the interpretation of 992?
If I remember correctly, it was in that case where Justice...
It was not raised squarely in the case of Diaz. In the case of Diaz, all the experts were civilists. In other words, experts in civil law. They did not raise the question
Yes,
of
Your
how it should be interpreted in relation to equality that related to illegitimate children, correct?
Yes, Your Honor.
In fact, counsel, would you know that in other jurisdictions, they no longer refer to them as illegitimate children, but many now refer to them as non-marital children. In fact, in Spain, where our civil code comes from, the word illegitimate is no longer there for children. Is that not correct?
To be candid, I am not personally aware of it.
Yes. As a matter of fact, in 1990, there was a very significant international event in relation to the rights of the child. Would you recall what this was?
National...
The Convention on the Rights of the Child,
Yes, Your Honor.
insofar as the Republic of the Philippines, was actually
Okay, sige.
ratified by our country. Correct?
Yes, Your Honor.
Yes. And the Convention of the Rights of the Child, because it was ratified by the Senate, how does it relate to statutes now?
How does it what, Your Honor?
If a convention is ratified by the Senate, how does it relate to existing statutes?
I would consider that that's part of our law already.
It's part of the law of the land, correct?
Yes, Your Honor.
And there are several theories to it, but the bottom line is that it must be given some leeway or some part in the interpretation of any existing statute. Is
Yes,
that
Your
not
Honor.
correct?
Yes, Your Honor.
As a matter of fact, there is Section 2 of the Convention of the Rights of the Child. Are you aware of this section?
Yes, Your Honor.
What does it provide?
That in all dealings or in all activities of the of private or public social welfare organizations or even the courts or even administrative agencies, the interest of the child should be of paramount consideration.
As a matter of fact, it's even more specific than that. Article 2, Section 1 of the Convention on the Rights of the Child specifically prohibit discrimination on the basis of birth. It is there in the, I had my staff put it in the PowerPoint. By the way, can this court take cognizance, even without the parties pleading, of the existence of a law?
Yes, Your Honor, please.
Ignorantia lehis non excusat, correct?
Yes, Your Honor.
Translated into English, what does that mean?
Ignorance of the law excuses no one.
Yes, which therefore implies that the law is supposed to be of judicial notice, correct?
Yes, Your Honor.
And even though you have not pleaded it in your petition, however, both amicus have actually pointed our attention to this convention which has been ratified, we have to take cognizance of that, correct?
Yes, Your Honor.
Yes, and if you read it, state parties shall respect and ensure the rights set forth in the present convention to each child within their jurisdiction without discrimination of any kind, irrespective of the child's or his or her parents' birth. I am removing the other provisions which are not relevant to our situation now. Does that mean that discrimination on the basis of birth, in accordance with the law or part of the law of the land, which is the convention, can no longer be a basis for distinction?
Yes, Your Honor.
At least insofar as minimum in interpreting existing provisions, we should try to minimize any kind of discrimination. Is that not correct?
Yes, Your Honor.
Yes. And therefore, whether a child is illegitimate or legitimate, at minimum, if the language of the text will bear it, we should avoid any distinction. Is that not correct?
Yes, Your Honor.
Now, why is that, counsel?
Because that is really for the best interest of the child. I mean, especially with respect to the legitimate status. To discriminate against a legitimate child in favor of a legitimate child is to penalize the child for something that he did not, that he is not liable for, Your Honor.
Yes. Except your petitioner is no longer a child. Except your petitioner is no longer a child. So does that rationale still apply?
I think it would still apply, Your Honor.
And as a matter of fact, the preambular clause of this convention mentions human dignity. Is that not correct?
Yes, Your Honor.
So it is not only the best interest of the child, but it's like having a skin that is black. That you should not be discriminated simply because you have a black skin. That you should not be discriminated because of what your father did. The fact is that you are a human being, and therefore you're supposed to be treated as equal as possible with other human beings. Is that not correct?
Yes, Your Honor.
But on the other hand, the legitimate children did not choose to have an illegitimate brother or sister. Is this not correct?
Sorry again, Your Honor.
The legitimate children did not choose to have illegitimate brothers or sisters.
Yes, Your Honor. They
And
do not.
therefore, it was also beyond their control.
Yes, Your Honor.
But in this case, this is not about an illegitimate brother. Is that not correct?
This is not about.
This is not about an illegitimate brother. Is this not correct?
Not. That's right, Your Honor.
Yes, this is about the offspring of a brother that should have, according to the law, that should have been a compulsory heir, that should have a share in the inheritance. Is this not correct?
Yes, Your Honor.
And therefore, could we say that this child of Arturo, who had no animosity with the family, simply wants what Arturo should have inherited?
Yes, Your Honor.
And had Arturo been living, perhaps that would have been what Arturo also wanted. Is that not correct?
Yes, Your Honor.
In other words now, counsel, in accordance with the provisions of the statutes that came after 1987, that was promulgated in 1990, it is now very clear that we should try to interpret the provision in such a manner as to avoid any discrimination or further discrimination to an illegitimate child, correct?
Yes, Your Honor.
As a matter of fact, if you want to go further, then you can even declare the provision as unconstitutional to that respect. Is that not correct?
Yes, Your Honor.
Because the Constitution does say equal protection before the law, correct?
Yes, Your Honor.
And equal protection before the law's interpretation evolves. If before in the United States, slavery was accepted, if before in the United States, a black and a white person could be separate but equal, today it is no longer an accepted basis for differences. It will be not only a difference, but a discrimination. Is that not correct?
Yes, Your Honor.
And today, because we are signatories to the Convention on the Rights of the Child, then therefore we have to interpret our provisions of the law in such a manner as to try to reduce the differences between a legitimate and illegitimate child. Is that not correct?
Yes, Your Honor.
Yes. As a matter of fact, this court is under duty to take into consideration all of these statutes. Is this not correct?
Yes, Your Honor.
Yes. And perhaps in your memoranda, you can elaborate on this theory, whether it in fact it is correct. Is that not correct?
Thank you, Your Honor.
Yes. Now, you mentioned the process of filiation. And you mentioned certain articles in the Civil Code. What are these articles, counsel?
The process of
Yes.
the proof of filiation, Your
Yeah,
Honor.
proof of filiation, I'm sorry. The process of proving filiation. There are certain substantive provisions in the Civil Code, and what are these? By the way, just to be clear, so Article 777 of the Civil Code says that succession happens upon the death of the decedent. Is that
Yes,
not
Your Honor.
correct?
Yes.
Immediately, it is the ownership transfers, correct?
Immediately transmitted.
Yes. And there is the right of representation that is contained in Article 970 of our current Civil Code. Is this not correct?
Yes, Your
Okay, the
Honor.
right of representation merely is the right of descendants to be able to take over the compulsory benefits that their ascendants should be able to get intestate or even with a will for the legitimate. Is that not correct?
Yes, Your Honor.
Yes. But it is also essential, just to be clear, that whoever represents should also be able to prove their filiation. Is that
Yes,
not
Your Honor.
correct? And therefore, it is important that we are able to be satisfied with the filiation of your petitioner to Arturo. Is this
Yes,
not correct?
yes, Your Honor.
Yes. And to this, we have substantive provisions. What are these provisions again, counsel? You did mention it in your opening statement.
With respect to the proof of filiation, Your Honor, the filiation can be proved in several ways. Number one,
This is in Article 170 2 of the Civil Code. Is this not correct?
Yes, Your Honor.
Okay, so the proof of filiation of a legitimate child is established by the record of birth. Is this
Your
not
Honor,
correct?
please. Yes, Your Honor.
Yes.
Appearing in the civil-
Is this possible in the case of your client?
No, Your Honor, please.
Why?
Because the father predeceased her.
Pardon?
The father predeceased the petitioner.
So the record of birth in the civil register, insofar as Maggie is concerned, does not contain the name of the father?
I'm sorry. I'm simply saying that she cannot, because there will be no signature of the father in the birth certificate, Your Honor.
No signature of the father in the birth certificate.
Yeah, because he had died already.
Okay. An admission of legitimate filiation in a public document. Does your client have that?
None, Your Honor.
A private handwritten instrument and signed by the parent concerned. Do you have that?
None, Your Honor.
None. Not even the instructions given by Miguel before he died
That
at
there is-
11:45 in the evening.
There is really no acknowledgement there of filiation, Your Honor, please.
Oh, you are now claiming and accepting that there is no acknowledgement there of any filiation.
As far as that particular instrument is
You realize,
concerned,
of
Your
course, that you have destroyed the case of your client.
Honor. I'm sorry?
That there is no acknowledgement of any filiation in the instructions given by Miguel.
No, Your Honor. I'm simply saying that in the written instruction that was dictated by Miguel Aquino, there is no acknowledgement of filiation. That's what I'm saying, Your Honor.
Okay, if you want to stand by that, it's on the record and you will stand by that for your client. Okay, I mean, counsel, this is the Supreme Court. You have to be careful about how you phrase your answers because everything is on the record and may be used against your case. But in any case, okay, in the absence of the foregoing evidence, a legitimate filiation shall be proved by 1, open and continuous possession of the status of a legitimate child. Does your client have this?
Again, none, Your Honor.
Open and continuous possession of the status of a legitimate child?
No, Your Honor.
None. Not even the fact that she lived with in the ancestral home?
That is an indication, Your Honor, please, but she is not a legitimate child.
We're not talking about legitimacy here, we're talking about filiation.
Yes, Your Honor. But
And Article 172, which speaks about legitimate children, is the same process for illegitimate children because the family code now makes it the same, correct?
Yes, Your
It
Honor.
was an improvement.
Yes, Your Honor.
Okay, and this is the process of filiation, correct?
Yes, Your Honor.
So therefore, open and continuous proof that she was a daughter of Arturo.
Yes, there is.
There
Your
is. And what are these, counsel?
These are the facts that were admitted by Respondent Abdulah Aquino, Your Honor. Number one, that before she was born, the expenses for the hospitalization were shouldered by her grandfather Miguel. The fact that after her birth, she and her mother lived in the ancestral home of the Aquino clan. The fact that all the expenses for her education from kindergarten level to college were shouldered by the grandfather.
Yes.
The fact that even in the dying instructions on the deathbed, there was an acknowledgement that she is entitled to a share in the estate, Your Honor, and that is why there was the instruction to give that particular lot to petitioner, Your Honor, please.
Okay. But Article 172 has some limitations. There is a prescriptive period, correct? Article 172 has some limitations. There are prescriptive periods.
There are specific period, Your Honor.
Yes, there are specific periods. So, for instance, to prove open and continuous possession of the status of a legitimate child, it must be done when?
During minority.
During the?
Minority, Your Honor.
Are you sure? Or does the law says it must be done during the lifetime of the father? Correct?
Oh, yes, Your Honor.
Yes. But that cannot be possible for Maggie because
Her father died already.
the father died already 9 months before. So it
Yes.
was impossible for her to avail of this provision, correct?
Yes, Your Honor.
And absent this provision, then you are removing and putting one more burden upon this illegitimate child. Is that not correct?
Yes, Your Honor.
Yes. On the other hand, to prove the first two, which is public instrument, etc., there is also a prescriptive period, correct?
There is, but
To prove filiation, on the other hand, other than the second paragraph of 172, there is also a prescriptive period.
yes, Your Honor.
What is that prescriptive period?
2 years, Your Honor.
2 years from
Discovery of the document, Your Honor.
what document are we talking about? I'm sorry, counsel. Again, to be able to avail of the method of proving filiation under 172, the first paragraph, what is the prescriptive period provided in the Civil Code?
Article 172, Your Honor.
Pardon?
Article 172.
Yes. Within the same period provided in Article 173, okay, which is during his lifetime and shall be transmitted 5 years within which to institute the action, correct?
Yes, Your Honor.
5 years within which to institute the action. That
Yes,
is
sir.
5 years counted from when?
After the death of the child, Your Honor.
After the death of the child, but your petitioner is still alive.
the child,
counsel.
yes, Your Honor.
Pardon?
After the death of the child. Your Honor, Article 173 provides that the action to claim legitimacy may be brought by the child during his or her lifetime and shall be transmitted to the heirs should the child die during minority or in a state of insanity.
So the 5-year period here is from the death of the child. It refers to his or her lifetime, so that refers to the ascendant, correct?
Yes, Your Honor.
Okay, so there is no 5 years for the ascendant here because the ascendant predeceased Angela, correct?
Yes, Your Honor.
And the 5 years counting from the death of the grandparent, on the other hand, correct?
Yes, Your
If it were from there, would have been complied with, correct?
Yes, Your Honor.
Because the grandparent, Miguel, died in 1999, correct?
Yes, Your Honor.
When did the counsel for your client file for the motion for inclusion?
2003, Your Honor.
2002 or 2003?
2003, Your Honor, because the petition was filed in 2003, Your Honor.
2003. So therefore, that is within the 5-year period, correct?
Yes, Your Honor.
Because 1999 was the death. Unless we count the 5-year period from the time of minority or upon the age of majority of Angela. Is that not correct?
Yes, Your Honor.
And that would be, when did Angela reach the age of majority?
She attained majority in 1996, Your Honor.
1996. So she should have filed for proof of filiation within 5 years from 1999, correct?
Yes, Your Honor.
Except that the case that mandated that the 5-year period can be reckoned from the age of majority did not happen prior to 1996, correct?
Yes, Your Honor.
As a matter of fact, it came after, correct?
Yes, Your
And
Honor.
this was the case of Bernabe, correct?
Bernabe
No
versus
relation to
Alejo.
the good justice here,
Yes,
but the
Your
case of Bernabe, is that not correct?
Yes, Your
Would you
Honor.
know the complete title of that case?
Bernabe versus Alejo, Your Honor.
Yes. When was that promulgated by the Supreme Court? That it mandated a period of 5 years from the date of reaching the age of emancipation within which to prove filiation. Okay? So that was promulgated in what year? Definitely after 1996, correct?
Yes, Your Honor.
Okay, and definitely, therefore, can it retroact to the case of your petitioner?
Can it retroact, Your Honor?
Yes. Can it apply to your petitioner when the case that gave that rule came after her attainment of the age of majority?
No, Your Honor, because the court decisions shall have prospective effect, Your Honor.
So the unique circumstances of this case is that the father predeceased her.
Yes,
And
Your Honor.
second, all the rules that apply to the prescriptive period could not be applicable, correct?
That's right, Your Honor.
And on the other hand, there were implicit circumstantial evidence that proved her filiation at the time that she was alive, correct?
Yes, Your Honor.
Yes, and therefore, by analogy, Tonsoy can apply.
Yes,
correct?
Your Honor.
That is your position?
Yes, Your Honor.
Yes. Okay. I have no further questions at this point, Your Honor.
Yes, Justice Bernabe.
Good afternoon, Counsel.
I'm sorry, Your Honor.
Okay, Counsel, can you read Article 163 of the Family Code?
Article 1,
163 of the Family Code.
I cannot recall it at this time, Your Honor.
Can you, do you have a family code? Can you go over it and read it?
The filiation of children may be by nature or by adoption. Natural filiation may be legitimate or illegitimate. Yes, Your Honor.
Okay, so based on this provision, do you agree that the concept of filiation has two senses?
Yes, Your Honor.
First, it pertains to establishing the relationship between a parent and a child, and which is either by nature or by adoption. And second, when it comes to filiation, natural filiation, the child is either legitimate, meaning born inside a valid wedlock, or illegitimate, meaning born outside a valid wedlock.
Yes, Your Honor.
Now, in this case, it is your position that Amadea has established her natural filiation as the child of Arturo.
I'm sorry, Your Honor.
It is your position that Amadea has established her natural filiation as the child of Arturo.
Yes, Your Honor, please.
And do you admit that Amadea was born out of wedlock and therefore she is an illegitimate child?
Yes, Your Honor.
Now, do you agree that proving the legitimate status of a child is different from proving the filiation of the child to his or her parent, the natural filiation?
Yes, Your Honor.
And insofar as proving the natural filiation of a child to her parent, you apply Article 172,
Yes, Your Honor.
which lists down the primary evidence
Yes,
for
Your Honor.
proving such filiation,
Yes,
and
Your
the secondary evidence,
Yes,
which
Your
you
Honor.
have earlier stated. Now, it is your position that Amadea has proven her natural filiation as the child of Arturo based on her open and continuous possession of the status as an illegitimate child.
Yes, Your Honor.
Is that correct?
Yes, Your Honor.
But of course, Article 175 states that the action to prove filiation based on secondary evidence, which is what you are claiming, must be brought during the lifetime of the alleged parent.
Yes, Your Honor.
And do you know the rationale behind that prohibition?
The rationale would be that in the lifetime of the parent, he is in the best position to prove that, Your Honor.
To either deny or dispute that claim, right?
Yes, Your Honor.
Now, but of course, Amadea is not precluded from proving by presenting primary evidence to prove her filiation, even after the death of the putative father, right?
Yes, Your Honor.
Okay. Now, did the treatment of Arturo's relatives towards Amadea stop them from resisting Amadea's claim of filiation to Arturo?
Yes, Your Honor.
Now, one of the requisites of estoppel by PAIS is that there is some conduct amounting to a representation of facts.
Yes, Your Honor.
Is that correct?
Yes, Your Honor.
And estoppel is an equitable doctrine that operates in the absence of law.
Yes, Your Honor.
Now, can the civil status of a person be subject to estoppel?
No, what?
The civil status of a person, can it be subject to estoppel? Or is civil status a matter of legal fiction that cannot be dictated by the acts of a party, but one based solely on judicial determination in accordance with law?
Your Honor, what can be established are the facts. And these facts are which give rise to the application of the doctrine of estoppel.
Now, may I refer you to Article 2035(1) of the Civil Code, which provides that no compromise upon the civil status of persons shall be valid. And status can refer to the status of legitimacy or illegitimacy. Now, since filiation cannot be subject to the express agreement of the parties, don't you think that all the more should stoppel, which is an implicit representation through conduct, not apply when it comes to filiation?
I think it should also apply, Your Honor.
Anyway, I'd like you to address that in your memorandum.
Yes, Your Honor.
Now, Article 992 of the Civil Code prohibits absolutely a succession ab intestato between the illegitimate child and the legitimate children and relatives of the father or mother of said legitimate child. Now, assuming that natural filiation is established between Amadea and Arturo, is Angela capable of representing the interest of Arturo in the intestate estate of Arturo's father, Miguel, considering your admission that she is an illegitimate child?
Considering what, Your Honor?
Okay, based on Article 992 and the case of Diaz versus Intermediate Appellate Court, can you say that Amadea is capable of representing her father in the intestate estate of the grandfather, Miguel?
Well, as Article 992 now stands, as it is read and as it is interpreted, she cannot.
Now, and of course, you earlier said that the basis of the iron curtain rule is the presumed intervening antagonism between the legitimate and illegitimate children.
Yes, Your Honor.
Now, this is the rationale behind the Iron Curtain Rule. Is this a matter of policy determined by Congress, or should the application of Article 992 of the Civil Code be made on a case-to-case basis depending on whether or not the legitimate family has accepted as their own the illegitimate child?
I would imagine so, yeah. Yes, Your Honor.
What is your yes? What
That,
does it mean?
It can be on a case-to-case basis, Your Honor, please.
It can be on a case-to-case basis.
Yes, Your Honor.
It's not a matter of policy that should be addressed to Congress.
Well, let me put it this way, Your Honor, please. As far as we are concerned, Article 992 is not a correct law. It is, in fact, unconstitutional because it creates a distinction which is not properly founded, Your Honor, please. You're talking about illegitimate descendants and legitimate descendants. You're talking of some provisions of the law, Your Honor, which provide the right of illegitimate descendants to inherit from illegitimate ascendants, Your Honor, whereas you are disallowing an illegitimate descendant of a legitimate ascendant from inheriting by right of representation.
And you do not think that there is a substantial distinction between illegitimate children and legitimate children?
There is a conflict, Your Honor, please.
There is a what?
Conflict, Your Honor.
Conflict. Okay, but are you saying that there is no substantial distinction?
There is no, I'm sorry.
Substantial distinction between legitimate children and illegitimate children?
You're talking about distinction between the two of them, Your Honor, please?
No, is there a valid classification?
Is there a?
Valid classification?
I don't think so, Your Honor, please.
You do not think there is a valid classification
think so,
between
Your Honor.
legitimate and illegitimate?
I don't think
You
so.
think they're all entitled to the same rights?
Yes, Your Honor.
All right. Thank you, Counsel.
Thank you, Your Honor.
Justice Kagiwa is next, please.
Good afternoon, Counsel.
Good afternoon, Your Honor.
I just want to clarify some facts in some of your positions. Okay?
Your Honor.
Amadea or Maggie was born on October 9, 1978, correct?
Yes, Your Honor.
On that date, it was the civil code that was prevailing, correct?
Yes, Your Honor.
On January 27, 1978 was the death of Arturo Aquino, correct?
I think Arturo Aquino. Yes, Your Honor.
Arturo.
Yes, Your Honor.
And at that time, it was also the civil code that was in effect, correct?
Yes, Your Honor.
Miguel Aquino, the grandfather, passed away on July 5, 1999.
Yes, Your Honor.
And at that time, it was the family code
Yes, Your Honor.
that was in effect, correct?
Yes, Your Honor.
The motion of Amadea to be included in the distribution and partition of Miguel Aquino's estate was filed on July 17, 2003, correct?
Yes, Your Honor.
On that date, it was the family code that was applicable.
On that date, Your Honor?
Yes, it was the family code, not the civil code that already
Yes,
was
Your Honor.
applicable. Correct?
Yes, Your Honor.
Now, just to be clear, is it Amadea's position that since she was born under the civil code, she has a vested right to assert her claim of filiation under the civil code?
Yes, Your Honor.
Therefore, under Article 285 of the Civil Code, she was a natural child, correct?
Yes, Your Honor.
And therefore, under the Civil Code, what she was entitled to do was to ask for recognition or acknowledgement.
Yes, Your Honor, please.
And under Article 285, she had a period within which to compel recognition, correct?
Yes, Your Honor, please.
And that is how many years, counsel?
4 years, Your Honor.
4 years. From the time she attained the age of?
Majority, Your Honor.
All right. And if she was born in 1978, she turned 18 in 1996, correct?
Yes, Your Honor.
And in 1996, when she turned 18, it wasn't the civil code anymore. It was the family
Yes, Your
code.
Honor. Yes, Your Honor.
Because if you follow the civil code, she would have attained the age of majority in 1999
Yes, Your Honor.
at 21 years.
Yes,
Correct?
Your Honor.
So in 1996, when Amadea turned 18, she could already exercise all the rights of an adult.
Yes, Your Honor.
She was no longer a minor, correct?
Yes, Your Honor.
Okay. I'd like to ask your position. Is it your position that Amadea reached the age of majority in 1996 at 18, or did she reach the majority only in 1999 at age 21 under the Civil Code? I'm not clear on what position you've taken.
Under the Civil Code, Your Honor.
Therefore, at age 21.
21, Your Honor.
And what is your basis for saying that?
Because at the age, under the Civil Code, the age of majority was still 21, Your Honor.
Correct. But she was born under the Civil Code and she attained at age 18 majority under the Family Code in 1996. In other words, my question to you is, in 1996, had she attained majority or not?
No, Your Honor.
Not yet.
Yes.
So in 1996, she could not exercise any of the rights of an adult.
Yes, Your Honor.
She was a minor.
She was yet a minor.
That's your position.
Yes, Your Honor.
And that position is reckoned only because she was born under the Civil Code.
Civil Code, yes, Your Honor.
Is that correct?
Yes, Your Honor.
Okay. The grandfather died in 1999. Correct? Correct?
Yes, Your Honor.
And at that time, what governed the succession in 1999?
The family code, Your Honor.
Sorry?
Family code, Your Honor.
The family code, but we're talking succession. So, under Article 777, succession happens at the moment of death.
Yes.
And the grandfather died only in 1999.
Yes, Your Honor.
Therefore, it should be the family code that applies,
Yes, Your Honor.
regardless of the age of majority of Maggie. Is that correct? Is that your position?
Yes, Your Honor, but the family code shall have retroactive effect, Your Honor.
Sorry?
The family code will have retroactive effect.
You're asserting a retroactive effect of the family code.
Yes, Your Honor.
On the basis of what?
The family code itself states under Article 255 that it shall have retroactive effect, Your Honor, please.
So it should have had retroactive effect also when she attained the age of majority at age 18 in 1996.
Yes, Your Honor.
Correct? Therefore, she should have filed her action within 4 years from 1996.
No, as I said earlier, Your Honor, she is covered by the Civil Code, Your Honor.
And yet, you're saying that upon the death of the grandfather, it is now the family code. So, which is it, counsel?
Under the Civil Code, Your Honor, this, as far as the age of majority is concerned, I'm just saying that under the provisions of the Family Code, the Family Code says that it shall have it can have retroactive effect, Your Honor. I'm just saying that that is a provision.
Yes, but I'm trying to clarify now your position, because the way I see it, you are very selective in choosing which law to apply.
I'm sorry, but
For what is beneficial to you, you cite the Civil Code. For what is beneficial to you in citing the Family Code, you cite the Family Code. So my question really is, what is the law that governs here when the decedent, whose estate is in question, died in 1999 under the auspices of the Family Code? That is my question to you.
the Civil Code, Your Honor, please.
So it's not the Family Code.
Not the Family Code.
Even if we are talking about the estate that opened in 1999. The death happened in 1999.
Yes, because the Civil Code still contains that provision in 1999 regarding succession.
In 1999, it was the Civil Code.
As far as succession is concerned, that successional rights are transmitted immediately upon the death of the deceased. As
Correct.
far as I know, Your Honor.
But the successional rights are determined by the status of the child.
Yes, Your Honor.
And yet, you're saying she will be governed by the Civil Code as far as her having been born under the Civil Code is concerned. Which is which? I just want to know where you stand, counsel. I have my own idea where I stand. It will affect her period to file.
Yes, Your Honor.
When you count the 4 years, 1996 or not?
1999 was the year Miguel died.
That was also the year she turned 21.
Yes, yeah.
So if she was to be regulated by the Family Code and she turned 18 in 1996, she only had 4 years from that time. And therefore her motion in 2003 is late.
Yes, Your Honor.
Agree?
Yes, Your Honor.
Okay.
That was not raised, though, in the proceedings below, Your Honor.
Yeah, but I'm raising it now. Do you agree with me?
Well, yes, Your Honor.
Okay, let me segue into something else. Estoppel. Is it your position that the other heirs, namely Abdulah in particular, is stopped from questioning the paternity of Amadea?
Yes, Your Honor.
Abdulah.
Yes, Your Honor.
Okay. Are you referring to the acts of the grandfather in the way he treated Maggie? Or are you referring to the acts of Abdulah in treating Maggie?
Both, Your Honor, please.
Have you, when we're talking about having stood as a godfather,
Having?
stood as a godfather to Maggie, I'm talking about Abdulah.
Yes, Your Honor, please.
Are there any other acts of Abdulah himself that show that he had recognized Maggie as the niece?
Well, the fact that petitioner here lived in the ancestral home without any objection on the part of any of the members of the Aquino clan, Your Honor. The fact that they celebrate anniversaries, weddings, etc. together, Your Honor. The fact that they did not question that the mother and daughter, Susan and Amadea, lived in the ancestral home, that is an indication, Your Honor.
They lived in the ancestral home at the time that the grandfather was still alive, correct?
Yes, Your Honor, please.
Therefore, can you actually say that Abdulah is stopped from questioning it when he was not the padre de familia, it was the grandfather.
He was not.
The padre de familia, the ancestral
Yes, Your Honor.
home belonged to the grandfather,
Yes, Your Honor.
correct?
Yes.
And therefore, the grandfather could allow anybody to live in his house, and his children would have no say to that, correct?
Well, theoretically, yes. But the treatment of the petitioner was as the daughter of Arturo, Your Honor.
The treatment by whom?
By Miguel, Your Honor, please. And the rest
The
of
grandfather.
Yes, Your Honor, and the rest of the Aquino clan.
And that's the thing that I want to ferret out. The treatment by the rest.
Yes, Your
I
Honor.
don't see that in the records except to say that she lived in the house and that she attended a lot of the family events. But do those equate to acts of Abdulah himself or to the acts of the grandfather?
Well, the acts alleged, admitted rather by Abdulah, pertain to the acts of the father, Miguel, not Abdullah's. But he is part of the family, and he also accepted petitioner into the Aquino clan family, Your Honor, please.
But right now, Abdulah is opposing her motion, correct?
Yes, Your Honor.
So at current,
But at the,
he does not recognize her as even a child of Arturo, correct?
yes, Your Honor, based on the opposition, Your Honor.
Exactly my point.
But as I mentioned, Your Honor, earlier, in the, I think, comment to the petition filed by Mr. Abdulah Aquino, he admitted the very acts which we say show the acknowledgement by the family, including Abdulah, of the petitioner, Your Honor.
He admitted the very acts which his father did, but not himself. I'm trying to make a distinction. I'm trying to tell myself, if we are going to talk about estoppel, are we talking about Miguel and the acts of Miguel? Or are we talking about Abdulah and the acts of Abdulah?
Yes, both, Your Honor, please.
Both.
Yes, Your Honor.
And the acts of Miguel are binding on the acts on Abdulah?
No, Your Honor, but they are independent acts, Your Honor.
But there are acts of Abdulah.
Yes, Your Honor, please.
Can I request that you specify all of these acts in your memorandum?
Yes, Your Honor.
Okay. Now, still on estoppel, it says under Article 1432 of the Civil Code that the principles of estoppel are hereby adopted insofar as they are not in conflict with the provisions of this code, the Code of Commerce, the rules of court, and special laws. So estoppel has a limited application. Agree? So
Yes,
long
Your Honor.
as it is not
In conflict.
correct?
Yes, Your Honor.
Article 992 seems to indicate a policy to create a division between legitimate and illegitimate heirs.
Yes, Your Honor.
Can I apply Article 1432 in the face of Article 992?
Well, that is precisely...
Talking about estoppel.
Yeah, that's precisely why we are saying that 992 is unconstitutional, Your Honor.
So you're not really relying on estoppel.
We are relying as part of our position, Your Honor, please.
But on the argument that it is not contrary to 992 because 992 is unconstitutional.
Yes, Your Honor.
I'm trying to understand your argument.
Yes, Your Honor.
Okay. Now, assuming for the sake of argument that you are correct and that the heirs of Miguel, namely Abdulah, is stopped from questioning the filiation, my next question is, again, prescinding from your argument on constitutionality, do the acts of Abdulah constitute estoppel also as to the application of Article 992?
Do the acts of Abdulah
Constitute estoppel so as to preclude him from invoking Article 992 of the Civil Code?
Yes, Your Honor.
They do.
Yes, Your Honor.
Okay. One last question for you. In the memorandum of Abdulah, at paragraph 29, he mentions a birth certificate of Amadea. And he refers to the husband or to the father not Arturo, but a Enrique Ho.
Yes, Your Honor.
Have you seen this birth certificate? I have not seen it. I just saw them. Justice Esmundo simply pointed that out to me. That in the memorandum of Abdulah, he mentions that there is a birth certificate of Maggie that shows that the father is not Aquino, but a certain Ho.
I have not
Are you
seen-
familiar with that?
I have not seen that birth certificate, but I had an occasion to recall that it was mentioned in one of the pleadings.
In the proceedings in the lower court, was this ever brought out?
No, I'm sorry, Your Honor. In one of the pleadings filed with the, I think, with the Honorable Court, Your Honor.
Only in the Supreme Court?
I'm sorry?
Only in the Supreme Court? You saw it only in the Supreme Court?
That's my understanding, Your Honor.
So
Your
it was
Honor, please,
never presented in the lower court?
as far as I know, it was not, Your Honor. Your Honor, may I clarify, Your Honor?
Go ahead.
I did not handle the case below. I did not handle the case at the Court of Appeals. In fact, I only came into the picture, Your Honor, about a week ago.
Oh, okay.
That's why I am not familiar with all the antecedents of this case, Your Honor, please.
All right. But for purposes of the memorandum, can you address that? Because that seems to throw a kink into everything here. If the birth certificate shows a father different from Arturo, then we might not even be talking about Article 992, because the entire filiation is put in question. Can you address that in the memorandum?
Yes, Your Honor, but offhand, can this document, if it is offered just now, can it be?
It is mentioned to be Annex 2 of the comment. Can I ask counsel for Abdulah? This was mentioned in your memorandum. Would you have a copy of that birth certificate? Thank you. I guess my question, counsel, is do you dispute the authenticity of this document? Where's the father? Juan Ho. All right. Sorry.
Hindi, mali eh. Kasi kalooban niya eh. Pinanganak siya sa kalooban eh.
A question, was this document offered in the trial? Was this mark offered, identified, authenticated, and so on? No. Thank you.
Wala yung value.
Yeah, but this is, what is this?
Where do we get the bearings of this?
No, but if there, but
Okay, let Justice Ben finish his interpellation, then we'll go to
yes,
the
I
other.
have. Thank you.
Go ahead.
Thank you, counsel.
Who's next? Justice Andy? Justice Andre? Okay, go ahead, please.
Your Honor, please. Counsel, how long have you been practicing law?
Since 1974, Your Honor.
I noticed, if you notice, that the petition came from a petition for issuance of letters of administration. Then you filed a motion to be included in the distribution and partition of the estate. Is that correct?
That's
That
what
issue- initial
petitioner
pleading.
filed, Your Honor, in the special
Yes.
proceedings.
You've been a practitioner. Don't you think the previous lawyers forgot to have a DNA testing
How?
to prove filiation? Don't you think the previous lawyers handling this case, when they filed that motion to be included in the estate
Your
of the
Honor. Yes, Your Honor.
estate, don't you think they forgot to resort to a DNA filiation test?
I don't know. I
So
have no knowledge,
don't you
Your Honor.
think the matters of your problem of trying to prove filiation could have been squarely addressed by a DNA test?
Maybe, Your Honor.
Maybe. What do
Maybe.
you mean maybe?
It's possible.
It's
I just
possible.
don't know the circumstances of the, for example, DNA testing can be done, but for example, the fact that Arturo died already in 1978, and if the DNA tests were done now, Your Honor, I don't know what tissues can be examined.
Well, the tissues can emanate from the grandfather, or can be emanate from the child, or can be
Well, maybe.
related, cross-related to a exhumation of the body, because you can extract DNA samples from the bones
Yes,
or
Your
the
Honor.
hair, which never perishes. You also mentioned about declaring 922 unconstitutional.
19,
Article 922 of the new Civil Code as unconstitutional.
992, Your Honor.
Yes?
Yes, Your Honor.
You're asking the court to declare it unconstitutional.
Yes, Your Honor.
Would this not be judicial activism on our part, that this is within the branch of Congress to enact the Civil Code?
No, Your Honor, please. Because I think it is within the powers of the court to declare a law unconstitutional.
Wherein the intent is very clear, because activism would mean that you deviate from the proper words of the statute.
Yes, Your Honor.
But not here, when the intent is very clear, that there is really a disqualification from a legitimate person to inherit, in this case, which is even harder to prove because you want to inherit from the grandfather.
Yes, Your Honor, but if we relate it to other provisions of the code, Your Honor, for example, the provision which entitles an illegitimate descendant from representing by right of representation an illegitimate ascendant, I think that that raises a question as to why that is so when under Article 992 we disqualify an illegitimate child of a legitimate ascendant from inheriting by right of representation, Your Honor.
But we have already declared, the court of appeals already declared that there is no proof of filiation between Arturo and the daughter. There is no proof that there was really a recognition because he died before that. So how can you really prove filiation?
Well, Your Honor, as mentioned earlier, there are several ways of proving filiation.
Won't that be an abuse on the part of the Supreme Court to amend this law, especially in the clear fact that there is absence of proof that your client is a descendant of Miguel?
Your Honor, it says that if you cannot prove filiation by means of a birth certificate or by means of an acknowledgement, a written acknowledgement of filiation, or by
Because
means
we have to bow to the intent of the legislature in this case.
Your Honor?
Correct? We have to bow to the intent of the law in this case. And I think it will not be right on our part to strike down a provision of the law where the basis is not clear. And it appears that your basis is not clear in this case.
Well, we feel that there is really no
What's that?
there is no valid classification, Your Honor, here.
You mean there's no justification for that rule? Are you telling me that? You mean there is no justification for Rule 922?
Yes, Your Honor, please.
Why do you say that?
Because here, as I was saying, Your Honor, there are provisions in the code which allow an illegitimate descendant to inherit by right of representation from an illegitimate ascendant.
From a person who has not to a person who has not proven his filiation? You can already inherit from a person who has not proven
Now,
filiation?
Your Honor, our position in this case is that while we were not able to and could not have proved filiation by the first three means under the rule, we were able to establish proof of filiation
No, you
by
were not able to
other
prove.
evidence,
You were not able to prove anything at all, except that there is apparently continuous recognition by the grandfather
There were-
by means of giving allowances and college tuition.
and these were admitted, Your Honor, by
Did he
respondent.
not say in writing that he's recognizing his granddaughter as a natural child? There's none.
There are
There are acts.
there was the judicial admission on the part of
What admission by Abdulah?
Yes, Your Honor, please.
That there is the daughter of his brother? Is that correct interpretation of the intent of 922 when you say to prove filiation? Can we prove filiation by another person?
Yes, Your Honor. By that judicial admission, we can.
So you state that in your memorandum, but
Yes, Your Honor.
I really don't agree.
Yes, Your Honor.
I will tell you that if we abandon 922, Article 922, it might destroy the legitimate property of the principle of the entire Philippines. Do you agree with me?
No, Your Honor, please.
Because what we are doing here is that the legitimate of the father, Miguel, will be subject to a confiscation of his property to people who are not his heirs. Secondly, if we allow the destruction of a legitimate, there will be no need for a marriage. Because anybody who coexists with a person, there's no need for a marriage. In this case, there was no marriage. But then, this person who was never married to the father, the daughter can inherit from the grandfather. So there is no need now for a marriage certificate, because the marriage certificate is the evidence of the right of the wife to inherit from the father and the right of the children to inherit from the grandfather. In this case, she is not part of the marriage certificate. She is out of the marriage certificate. So I'm saying, amending 922 will change entirely the civil structure of the Philippines, because we are destroying legitimate property, the regional legitimate property, and we're destroying the recognition of a marriage. We will be allowing people to just live together. And every girl who is pretty will not want to get married anymore. She will just have children with a lot of rich people in the hope that later on, her children can inherit from the rich people. So I should put that in your memorandum, why we cannot or why we should abandon Article 922, because Article 922 was based on common good. Do you know what is meant by common good?
What, Your Honor?
Common good.
Goben?
Common good. Do you know what is meant by common good? You know that term, common good of the country, common
Yes, Your
good
Honor.
society.
Yes, Your Honor.
Do you know what is meant by good father of a good family? Parents patria.
Yes, Your Honor.
So I hope you put this into your consideration. And you talk about the acts of Abdulah, correct? Acts of Abdulah. You said because of Abdullah's act and the acts of Miguel, the grandfather, the child is presumed to be legitimate or recognized. Is that correct?
Natural child, Your Honor.
Yes. If you were in a single person, you have the right to marry a person. Is that correct?
Yes, Your Honor.
If you don't want to marry this person, excuse me to the petitioner, if you don't want to marry a person, you don't marry her, right? You don't marry her. Or maybe you don't want to marry her, you don't want to give your property to her. Is that right? Can you say you can interpret refusal to grant a property to a person by not marrying her?
May I move closer, Your Honor?
Yes, yes. By not marrying a person, could you assume that the person who didn't want to marry a girlfriend, he doesn't want to give his property to his girlfriend, that's why he doesn't want to get married? Yes. Yes. Yes, Your Honor. So in this case, there was no marriage.
They are also.
There was no marriage.
There was no marriage. None.
But you said they were. He was pregnant. They were living together. Is that correct? No.
Yes, Your Honor.
They were living together.
Yes, Your Honor.
And was there a marriage invitation or marriage application?
As far as I know, none, Your Honor.
None. So maybe you should discuss this also, because you're making the respondent stop by the acts of Abdulah, but you have failed to dwell on the acts of Arturo, the one who is the father of the petitioner.
But he died ahead of the petitioner, Your Honor. Please.
That's why can we not interpret his acts of not marrying his girlfriend as a sign that he does not want to part his property?
Not necessarily, Your
Necessarily.
Honor. Not
So,
necessarily.
but it could go either way. Yes, Honor. Is that correct?
Yes, Your Honor.
Excuse me, can you use the mic, counsel, so that the other parties can hear your answers?
So you still insist that a person who has proven filiation can inherit from the family of his late father, alleging that he is the son of a father, daughter of a father. Is that correct?
No, but precisely, Your Honor, our position is that she has proven her filiation, Your Honor.
You mentioned about the Constitution regarding rights.
I'm sorry?
Rights of the people, rights of your client. What about the rights of the fathers and the brothers of Abdullah's rights and their children's rights? Are they not also going to be compromised by asking them to give a part of their property to somebody who to them is not really a relative?
Well, to their perception, maybe not. But if she is in fact part of the family, then she should be entitled, Your Honor.
If we grant this petition, would not the court be exercising undue confiscation of property without due process?
I wouldn't think so, Your Honor, if it is established on law and evidence, Your Honor.
Isn't due process trying to prove a relationship between the person who wants to inherit and the person? And you have not proven the fact of filiation?
Precisely, we're saying that we have proven this by the admission, Your Honor, of the acts.
Anyway, I have no further question at this point.
I'm sorry.
Thank you so much.
Thank you, Your Honor.
Justice Dewey, Justice Alex would like to first ask the questions. Okay. So Justice Gesmondo then.
Good afternoon, counsel. May I ask this question
Good afternoon,
on
Your
the
Honor.
petitioner? If the petitioner is willing to yield some questions of the court?
The petitioner, Your Honor?
Yes.
Yes.
Thank you so much, Your Honor. Thank you so much for having me here. Thank you so much, Attorney Anastasio, for helping me out.
Okay. Good afternoon, petitioner. There was an issue earlier because of the mention of the birth certificate purportedly indicating that you have a father by the name of Enrique Ho. Is that right?
Yes, there was an issue raised.
Do you know
earlier.
this
Correct.
Enrique Ho?
Yes, I do.
How did you come to know him?
He is the second husband of my.
Okay, please speak louder.
He is after my mom met my dad. After 4 years, he married my mom.
So this is the
So
present
he is the ex-husband of my mom.
ex-husband of your mother.
Correct.
And your mother contracted marriage with Enrique Ho when?
When I was 3 years old, 4 years old.
You were 3 years old. By that time, you were no
Correct.
longer residing at the place of your grandfather?
Yes.
Now,
Correct.
you have been, earlier you said that your counsel said that you are presently residing in the United States. Is that correct?
I'm living in New York, Your Honor.
And what passport are you using?
Right now, I'm using my U.S. passport.
And prior to that, you had Philippine passport. Is that correct?
I have my Philippine passport, correct.
And what birth certificate did you use in obtaining that Philippine passport?
Your Honor, I used the one for my
Your stepfather.
the husband of my ex-husband of my mother now, correct.
So which, are you referring to the birth certificate that was shown to the court today?
Yes.
Can you show it to the counsel for Abdulah Aquino to show it to the
Yes,
petitioner?
Your Honor. This birth certificate, Your Honor, was made by my mom when I was younger because for the reason that she wanted to protect me from people teasing me, and she wanted to bring me in a school, and this was a requirement. She didn't want people to tease me that I have different, I have a different father to my future family.
May I ask again?
So this, yes, Your Honor.
So, moment. That birth certificate was obtained 3 years after the death of your father.
Correct. Yes, Your Honor.
And the one who caused that birth certificate to be registered is your mother.
Yes, Your Honor.
Okay. And since then, you have been using that birth certificate for your official transactions. Is that correct?
Yes, Your Honor. As a matter of fact, the Aquinos know about this. They know about this. It was not a secret to them. We even asked permission from my tata when this happened, because they wanted to try to protect me from.
Are you telling the court that your grandfather, Miguel Aquino, was aware?
I'm sorry?
Of your grandfather, Miguel Aquino, was aware of the existence of this birth certificate?
Absolutely. My
How old are you?
grandfather
How old?
and my sorry.
How old were you when your grandfather, Miguel Aquino, passed away?
I'm not sure I remember how old I am.
How old were you? You.
When
He
I
passed
was
away
that time,
1999,
1990, yeah. So
right?
I'm 1978. Yeah,
So how old were you at
I
that
don't
time?
remember. How many yun? 21. Yeah, 21.
You
I
were
believe.
21 years old at the time your grandfather passed away.
Correct.
And you're telling the court he's aware that your birth certificate indicates Enrique Ho as your father.
Yes, Your Honor. He was aware, and the whole Aquino clan is aware, Your Honor, of this. And they accepted this, that they knew that we had to come up with this just for school purposes, Your Honor.
Did you have any brothers or sisters by the subsequent marriage of your parents?
I'm sorry, Your Honor?
Did you have brothers or sisters or siblings as a result of the marriage of your mother with Mr. Ho?
Yes, Your Honor.
So you have half brothers and sisters.
Yes, Your Honor, I do.
Okay,
My-
thank you.
Sorry.
Thank you very much. May I ask counsel a few questions? Mr. Counsel, in your opening statement, you made mention that the Aquinos are in Stoppel to question the affiliation of Angela. Is that correct?
Yes, Your Honor.
And what is your basis in that assertion?
Because, Your Honor, because of the admission made by Abdulah, Your Honor.
How did this admission was made by Abdulah? How was this admission by Abdulah made?
In a comment filed, I think, with the lower court.
What is that file? Can you tell it to the court?
This was a basis made by the respondent Abdulah, Your Honor.
Can you speak clearly, please?
In the submission with motion for approval of partial partition. No, I'm sorry. To the comment to the petition dated November 14, 2003, Your Honor.
What pleading was that?
This is a comment to the petition, Your Honor, dated November 14, 2003.
November 14?
Yes, Your Honor, please.
Because I have here with me as Annex 1 of Abdullah's memorandum, which I'd like to read for the record. This is to certify further that no testimonial and documentary evidence was presented and offered both by the petitioner and the movant pertaining to the April 22, 2005 order of the court, referring to the declaration of the court that the petitioner should be entitled to the portion of the estate. So where can the court now, as it is, rely on your assertion that the Aquinos are in estoppel since there is no evidence presented before the lower court?
Your Honor,
What
please.
will be our factual bearing?
Your Honor, please. What the record shows that under date of July 2, 2003, petitioner filed her motion to be included in the distribution and partition of
Correct.
the estate. Your
That's
Honor.
not disputed, but
And in this petition, in this motion, Your Honor, she alleges, among others, that the following, Your Honor.
yes,
Number one, it was Arturo Aquino's family.
no doubt she made those allegations, but allegations are not proof.
I'm sorry, Your Honor.
Allegations are not proof.
Yes, Your Honor, but as we had indicated later, all these allegations that are mentioned here were admitted by Respondent Abdulah in his comment to the petition dated November 14, 2003, Your Honor.
And how was the admission made?
In a comment, Your Honor.
How? Can you please read that to the court?
I don't have the pleadings actually right now.
You are saying that this that will be in the nature of judicial admission.
Yes, Your Honor, please.
So let's read and see how it's made as how can you treat that as a judicial admission?
I don't have the copy of the comment, Your Honor.
Counsel for Abdulah, would you have a copy of that comment? Because as it is, there is no factual bearing that the court can take into account in resolving this petition.
Your Honor?
Based on this statement in the certification, since no evidence was presented at the trial court, where will the court get its factual bearing to resolve the instant petition?
I understand, Your Honor, the certification, but what I'm saying is that there was a judicial admission by Abdulah.
That's why the court is saying, where is that judicial
Yes, Your Honor.
admission? We know that in Rule 129, what need not be proved. But where is it? Okay, show it to the counsel for the petitioner and read for the record what constituted judicial admission that there is no proof required for that purpose as to those facts. Because your main argument is that the Aquinos are in estoppel because of their acts.
Yes, Your Honor.
And what are those acts?
The acts, Your Honor, that were admitted, Your Honor.
No, show in that comment
Okay.
what constitute judicial admission that will not require proof anymore as to those facts constituting the estoppel. Can any of the collaborating counsel assist the lead counsel to expedite the proceedings? Because I'm relying on the certification issued by the
Yes, Your Honor.
branch clerk of court that there was no evidence presented by both parties, meaning both the movant and the oppositor, as regards the motion and opposition to the claim of petitioner.
Paragraphs 1, 2, 3, 5, petition.
Okay. Please address that in your memorandum.
Yes, Your Honor.
Thank you, Mr. Counsel.
Thank you, Your Honor.
Justice Dewey? Okay.
Thank you, Chief. May I propound some questions to Attorney Anastasio?
Yes, Your Honor.
Can you hear me?
Yes, Your Honor.
Loud and clear.
And
All right. It would appear that the main issue, there are several substantial issues that you presented in your pleadings. And it would seem that the major issue is whether petitioner Angela can inherit through interstate succession from Miguel,
yes, Your Honor.
her
Grandfather.
grandfather,
Yes, Your Honor.
by representation of her father, Arturo.
Yes,
right?
Your Honor.
Now, can you tell us, Attorney Anastasio, well, you said you answered in the affirmative, right?
Yes, Your Honor.
All right. Now, what is the legal basis for your answer?
Well, part, Your Honor, is that the facts established or admitted, which was, as we were talking about earlier, indicate that she is an heir. She
Okay.
was,
You're telling us that the facts of the case show that
She is the natural
or,
child of,
Angela is
Arturo, Your Honor.
related to Arturo, that
Yes, Your Honor.
she is the daughter of Arturo, although the birth certificate now presented shows otherwise. But anyway, let's set that aside first. You are familiar with, we've been discussing here since 2 o'clock, the so-called iron
curtain.
bar rule, or is it iron
Curtain.
curtain rule? I think it should be the other one, the iron bar rule, right? Well, anyway, however you call it, Article 992 would appear to prohibit illegitimate children, as stated earlier, from inheriting.
Yes,
right?
Your Honor.
Right. Inheriting interstate from the legitimate children and relatives of his father or mother. Now, what is the, Attorney Anastasio, what is the prevailing interpretation of the word relatives as found in Article 992?
My understanding of the current interpretation of relatives is that it is a general term, and therefore should include relatives whether in the ascending or collateral.
So the word relatives as used in Article 992 and as established in the case of Diaz versus Intermediate Appellate Court, decided February 21, 1990, is that the term includes legitimate ascendants of illegitimate children such as grandparents. So 992 therefore bars or prohibit illegitimate children from inheriting. That is why it is called iron bar rule. Is that correct?
Yes, Your Honor.
So, you cannot use Article 992. Or can you use 992 to support your position that Angela, is it Angela, or Maggie can inherit?
Your Honor, if we have circumstances which will destroy the legal presumption behind the Iron Curtain rule, which is the supposed existence of animosity between the legitimate and illegitimate families, then that Article 992 should not be made applicable.
Okay. As it is now, Counsel, the iron bar rule would prevent
Yes,
an illegitimate
it is
child
the prevailing.
from inheriting,
Yes, Your Honor.
right? Now, but are you aware of the dissenting opinion of, in the case of Diaz versus Ia, are you aware or do you know the dissenting opinion of Justice Hugo Gutierrez in that case?
Yes, Your Honor, please.
Yeah, okay. What was his opinion?
He's saying that he's talking about the so-called ancient wall or the Iron Curtain as having been breached already
Yeah, well,
by the Code Commission.
well, to my mind, the dissent of Justice Hugo refers only to collateral relatives. And that would, in other words, it is the view of Justice Gutierrez that only collateral relatives are included in the word relatives.
Yes, Your Honor.
So I think that should be your answer.
Your Honor?
That should be your answer.
Yes, Your Honor. Yes, Your Honor.
So are you saying now that we have, we have to revisit the case of Diaz?
Yes, Your Honor.
Now, Attorney Anastasio, is the case of Diaz versus IAC favorable to your client or not?
Not favorable to my client, Your Honor.
How's that?
Not favorable, Your Honor.
It's not favorable as it is. But the dissenting opinion would be quite
Yes, Your Honor.
reasonable, right? All right. Now, Attorney Anastasio, earlier, I think two of my colleagues mentioned about entering into a peaceful solution.
Entering into what?
Entering into a compromise agreement maybe or a settlement. And I heard you said earlier, you answered in the negative.
No, Your Honor. I said that it would be best to have a compromise solution.
It would be...
I always view that the cases like that, Your Honor. As much as possible, if you can settle the disputes, the better, Your Honor.
Yeah, especially cases of this nature.
Yes, Your Honor, especially involving relatives.
Partition, settlement of estate. Cases of this nature usually go up to the Supreme Court.
Yes, Your Honor. I'm aware of that.
And parties, in the end, are at the disadvantage, meaning with lawyers, benefiting from these cases, right? But anyway, setting aside legal matters, Attorney Anastasio, talking about settlement. What are the parties here? All of them? I saw Angela or Maggie earlier. Is Rodolfo and Abdulah, the counsel of Abdulah is present? Is Abdulah himself present? He is not. About Rodolfo. You're the counsel of Rodolfo? Could you speak louder?
Yes, Your Honor, I'm the counsel for Mr. Rodolfo.
And who are the other parties present? Because in the advisory, the names of Rodolfo, Abdulah are mentioned. And since the names are enumerated, it is incumbent upon you to bring them here and at least to say something when called by the court. Just like earlier, the court requested the petitioner herself to come and answer some questions. So anyway, what do you think of entering into an amicable settlement, even at this late stage? Because courts are encouraged to assist the parties to enter into amicable relationship. Now, how would you describe the relationship of Angela with her uncles, yung mga tito niya? How would you describe the relationship? Is it cordial? Is it civil? Or is it what? Because I noticed, you just use that phone there, that microphone. Do you agree? Do you accept? Do you agree that Abdulah is the ninong of Angela in baptism? Totoo ba yun?
Your Honor, I cannot speak for Mr. Abdulah, Your Honor, because he's not my client. My client is Mr. Rodolfo Aquino.
What do you say? Attorney, your attorney?
I'm Attorney Geraldine Vicky Mossing to you, Your Honor. I did ask my client about the fact of the baptism, but according to him, he cannot recall ever being on that occasion.
He can't recall that Angela is, or that he is
that
the
he
ninong?
was the godfather, Your Honor.
Again?
He could not recall that occasion
Could not
of being
recall.
her godfather, Your
All
Honor.
right, be that as it may. How would you describe the relationship?
It's not friendly, it's not cordial.
Again? How is
They're
that
not on
please?
friendly terms, Your Honor.
It's not good.
Yes.
And so with Rodolfo.
Yes, Your Honor.
So it would seem that there is no way by
Yes, Your
which, because before we can help the parties arrive at an amicable settlement, then at least they must have a very good relationship. But can you, as officers of the court, help while the case is being resolved by the court? Can you not?
We can always try, Your Honor, of course.
Not try, but do it as officers of the court.
Yes, Your Honor. But we have to also make it a record, Your Honor, that the heirs of Miguel Aquino, excluding here the petitioner because she is not admitted as an heir, they already entered into a compromise agreement, Your Honor, before the regional trial court, and it was approved by the regional trial court,
Who
Your Honor.
entered into an amicable settlement?
Mr. Abdulah Aquino, Rodolfo Aquino, the heirs of Wilfredo Aquino, and the wife, the surviving spouse,
All right.
Enery Aquino, Your Honor.
So leaving Arturo.
Yes, Your Honor.
But Arturo does not have children other than Angela.
Yes, he
Assuming
predeceased
that
the
she
decedent.
is a child of Arturo. So
Assuming, Your
why
Honor.
didn't you include the heirs of Arturo like Angela when all of them have entered into an amicable settlement?
It is...
Oh, by the way, I hope you don't mind my asking you, what is the value of the entire estate of the Aquino?
We don't have the present valuation, Your Honor.
Yeah,
but
just a rough estimate. No, because why are they so concerned about,
it
the
consists of
estate?
several valuable commercial properties in Davao City, Your Honor.
Properties, real
Yes,
properties.
Real properties,
All right.
prime
Now-
lots, Your Honor.
Now, these real properties were included in the amicable or compromise agreement before the RTC.
Yes, Your Honor.
All
So
of
it
these
would seem that
properties.
there is a chance.
That is why, Your Honor.
Has it been approved? Has the compromise
Yes,
agreement?
we already have
a
the
judgment has
judgment
been
on
rendered?
compromise agreement, Your Honor, in
All right, so
2016.
why not include even at this late stage? Angela,
Excuse me, Justice Reyes, you still have questions directed to the counsel of the attorney, the counsel of Margie? Can we finish first because we're already running out of time?
Okay.
Please lang, please. No.
Please.
Where's
Yes,
the-
Anastasio, what can you say about the existence of a compromise agreement entered into by the three children, Rodolfo, Abdulah, and Wilfredo, as represented by his legitimate heirs, but excluding Maggie or Angela?
Number one, Your Honor, I'm not aware of the compromise agreement. Number two, if there was such a compromise agreement, I would suppose that should have included the Amadea Angela, Your Honor.
Well, it's not too late, Attorney Anastasio. I think you can, having entered your appearance only recently, I think, I'm sure the other lawyers of the other parties here can accommodate you.
Well, hopefully.
Can you talk things over? Yung mga counsels ng other relatives? So that we can
As I said,
terminate this case. Where is that compromise agreement before the RTC? It's there? All right, nothing was given to Angela?
No, Your Honor.
So why can't you...
Like I said, I don't know of the compromise agreement.
that could be a starting point. The Solicitor General will be too happy to, to end this case and help the parties altogether. Anyway, before I end, there's a saying, this was even the favorite statement of Senator, the late Ninoy Aquino. He said that, when science ends, when you can find answers, you can find solutions to problems around us. When science ends, faith begins, right? When science ends, faith begins. So why can't you use this? Meaning, faith in whom? I think you're a Catholic, Attorney Anastasio.
Faith in God, Your Honor, please.
Believe in God. And God, according to one of my colleagues here, God works in mysterious ways. Okay, so please try to do something about this on the religious side and on the legal side. We have done that. We have exhaustively discussed the issues of the case, I believe. But don't forget the religious side. And I'm sure...
Personally and in behalf of my client, we welcome that, Your Honor.
Okay, that's good. Thank you, Attorney Anastasio and the other counsels. Thank you, Chief.
Okay, Justice Hernando, please.
Thank you, Chief. Just short questions from the amicus. May I be permitted to ask questions from our esteemed amicus curiae? Firstly, to Dean Cynthia Del Castillo, Ma'am. May I, thank you, Attorney Anastasio.
Thank you, Your Honor.
Good afternoon, Dean.
Good afternoon, Your Honor.
Filius nullius, a child with no father, is an obnoxious vestige of empire days. Don't you agree? I'm referring to the Roman Empire because this concept of a child with no father has its origins from Roman law. And this was fortified during the Middle Ages by Henry VIII, no less, the King of England, who had many wives and many children. And he had to protect the shares of his legitimate children from the illegitimate ones that he had sired. And so he came up with the laws of bastardy in England. And In the 16th and 17th century, France embraced the same concept. But in the latter part of the 19th century, France became enlightened. And since then, European countries that were born out of empire days had embraced an enlightened approach to the status of illegitimate children. Nowadays, they don't use illegitimate as a term, but rather non-marital or non-paternity. And the United States has followed suit last century, in the 20th century. In a number of cases, the United States Supreme Court has come up with benevolent rulings on the rights of illegitimate children with respect to succession. And it is that essentially these laws on bastardy are so much so discriminatory towards these children, the non-marital children. And it's not just the United States that has come to embrace this modern trend towards giving equal rights to both legitimate children on the one hand and illegitimate children on the other hand. And closer to home, a grand bench ruling of the Saiko Saibansho of Nippon, I'm referring to the Supreme Court of Japan, has also adopted this modern trend towards giving equal rights, at least from the perspective of succession, to both legitimate and illegitimate children. The Supreme Court of Japan said in its grand ruling or grand bench ruling in 2013 that these illegitimate children never really had a choice and have no power to alter, and which is why it is now the bounden duty of the state to equalize to level the playing field, so to speak. But interestingly, in Japan, unlike the United States Supreme Court, based its ruling on public opinion. And the modern trend in international law to give equal rights to all kinds of children, whether legitimate or illegitimate. And so the Saiko Saibansho of Nippon did not adhere to the heightened scrutiny test that the United States Supreme Court has applied in, I think you cited a number of cases in your memoranda to the High Court, Madam Dean. And the basis for the ruling of the Supreme Court of Japan was, as I said, on public opinion and modern trend of international law. Public opinion, because it looked into statistics in Japan, in Japanese society, where there was an increasing number of non-marital children whose rights had to be protected, just like legitimate children. And then international law, because Japan is a signatory to the UN Convention on the Rights of the Child. Interestingly, Japan signed it belatedly. Our country ratified it ahead of Japan. We ratified it in 1990. Nippon only ratified it in 1994. And yet, they now have this more progressive stance towards the successional rights of legitimate children. And I found it very interesting that in the memorandum of Professor Pangalanan, the number of illegitimate children or non-marital children in the Philippines as of 2017 is now more than 50%. And to be more exact, it's 53% in fact. The region that has the most number of non-marital children can be found in Eastern Visayas, about 65%. NCR follows next at 64.9, very close statistical difference. And so we see that in our society, I believe that we need to give protection to these children because they now outnumber our legitimate children, 53% to 47%. Now, if we are going to give equal rights to these children, Dean Cynthia, how do you propose we go about it? Shall it be by way of judicial rulings or legislative measures?
In my submission, Your Honor, I did say and I did cite several cases in the United States that have struck down legislations that made a distinction between legitimate and illegitimate children. We do not have a case law in the Philippines which is of similar import. But if we can go towards the Western countries with far more advanced communities that we have, we can look towards the U.S. And the cases I cited in my memorandum or in my opinion, which is submitted today, shows that this is no longer considered as a matter of substantial distinction. So the Supreme Court cases really said that there is no substantial difference between legitimate and illegitimate children. And the distinction that were made in the U.S. legislations making a difference between legitimate children and illegitimate children were not really germane to the law. So in matters of succession, I guess the question for this court is it germane to the law? In most cases, the answer would probably be no. But at the center of this controversy, you have Article 992, which of course makes the distinction between legitimate and illegitimate descendants of a legitimate child. In my submission, Your Honor, I did say that 992 can be considered, first, as being unreasonable. Secondly, it is inconsistent. Third, it is something, as many of the cases have actually said, it leads to an absurd situation. And the last, of course, and not the least, is the issue of constitutionality. If I may be permitted, Your Honor, the issue of unfairness is the one that strikes the heart at most. You have here a situation, if I can go into a specific example, this is solely on the basis of the legal principles under Article 992 and nothing to do with the factual situation in the case. If you get a specific example of a person who dies with a legitimate child and the other one is an illegitimate child, and they are all, and both of them have illegitimate children, if they predecease the grandparent, who will inherit? It's the illegitimate child of the illegitimate son, excluding completely the illegitimate son of the legitimate son of the grandparent. So you have a situation here where you actually favor the illegitimates over the legitimate. Is this a fair situation? So this is the heart and soul of Article 992. If it can be struck down as unconstitutional on the basis of the fact that there is no substantial distinction, it really is going to be something that favors not only the illegitimate children, but the legitimate children as well. So if you look at the other parts of the world, the trend is changing. But even if you come close to home, if you notice, you had the statement of Justice J.B.L. Reyes and the memorandum of the Code Commission. Even in 1950, when they were changing from the Spanish Civil Code to the current, to the new Civil Code, there was a very specific statement, and this is carried on in all of the succession cases dealing with Article 992, that this is something that was not envisioned by the legislators even at that time. If you look at the statement of Justice J.B.L. Reyes, which is of course a very illustrious and respected civilist in this country, he said that Article 992 was a literal translation of the Spanish Civil Code, and called the Spanish Civil Code, of course, as something which is out of time, even in the 1950s. It was archaic, it was ancient, it was based on the Spanish distinction between legitimate and illegitimate children. The era of the Spanish time is long gone. In the 1950s, even President Rojas and even J.B.L. Reyes had said that this was not the intent of the new Civil Code. The intent of the new Civil Code was to equalize or at least give more rights to the illegitimate children. So the distinction between legitimate and illegitimate, I think, is several decades long overdue. Today, in the year of the 2019 now, this is really so much so that it is irrelevant to make that kind of a distinction,
Yes,
Your Honor. And I agree with you.
We're in the 21st century, Madam Dean, and the first laws on bastardy were first promulgated in 1070, 10 centuries ago. So I say that this is really a very obnoxious vestige of empire days that we need to strike it as unconstitutional at this very moment.
I
But
think, Your
be that
Honor,
as it may, there would be complications, Dean, because if we're going to strike down as unconstitutional Article 1992, then are we going to apply it retroactively or retrospectively? I mean prospectively or retroactively? I'm asking that because there was this complication in Japan that came about because of that grand bench ruling of the Saiko Saibansho of Nippon. And that is that they had a problem with the retrospective application of their ruling that these discriminatory laws against illegitimate children would have to be applied prospectively or retrospectively. And eventually, they came up with another grand bench ruling to the effect that as of 2001, which was the first grand bench ruling that upheld the constitutionality of their provision on succession with respect to illegitimate children that's similar to our Article 992, they had a timeline that the retroactive application shall not come about by or reckoning it at 2001. Beyond 2001, it's prospective. So discriminatory beyond 2001. But in the meantime, the Saiko-san, or short for Supreme Court of Japan, made a recommendation to their parliament that remedial laws would have to be passed to address the interregnum. So if our Supreme Court would strike down as unconstitutional Article 992, then should it be prospective in application?
my own position, Your Honor, is that when you declare a law as unconstitutional, it never became a law. So is it something that we can just apply prospectively? It's a matter addressed to these courts because it is always possible for the court to consider that certain rights have vested before the declaration of the unconstitutionality. So it's really, on its very concept, when you say unconstitutional, it was never a law. And therefore, it should apply to all cases. But on the basis of the fact that you can consider that certain rights have vested before the declaration of unconstitutionality, then we can go forward on the principle of prospectivity.
Thank you so much, Dean.
Thank you.
Mr. Chief Justice, may I be permitted just 5 minutes to ask questions also from
Yes, go ahead.
our other amicus, Professor Pangalanan? Just a short question.
I'm only acting Chief Justice for today.
In due time, Your Honor, you will be regular Chief Justice. Good afternoon, Professor Pangalanan.
Good afternoon, Your Honor.
I'm so struck by the statistics of the PSA. It's the first time I came to know that we now have more non-marital children in our country than marital ones.
Yes, Your Honor.
And what's the significance of that? At least from, or in relation to the case that we're now hearing, Professor. Does it have any bearing?
Yes, Your Honor, definitely, Your Honor. What I tried to show in my memorandum that I filed with the court yesterday is that if the purpose of 992 and other provisions, which treat the rights of legitimate and illegitimate children or marital and non-marital children, is to promote the institution of marriage and protect traditional family, protect legitimate family relations, then we should look at how many, in fact, have been deterred from entering into sexual relations outside of wedlock in order to promote the traditional marriage setup, and how many have avoided entering unmarried cohabitation for fear that one day their children who are born outside of wedlock will not enjoy successional rights and other rights from the former's legitimate relatives, Your Honor. And so I went to statistics and was myself surprised that more than half of those born in 2017, which is the latest data of the Philippine Statistics Authority, were born out of wedlock. Therefore, Your Honor, I posited the view that in this context, the legal and societal disadvantages suffered by illegitimate children have not sufficiently deterred unmarried couples from creating them. Therefore, Article 992 of the Civil Code and other provisions, such as Article 175 of the Family Code, that deny illegitimate children rights merely because of their status does not achieve any state interest and is inconsistent with our treaty obligation, Your Honor.
The bigger number of non-marital children, as shown by statistics, would that also be reflective of a change in societal attitudes with respect to marital children on one hand and non-marital children? Meaning that, is it safe to assume, based on these statistics, that now it's more acceptable? Our society is more than willing to accept non-marital children as as human beings, equal in the eyes of the law and of God and of everything else that stands in our universe.
I believe so, Your Honor. That 21st century Philippines included now has a more open mind about non-marital children, although that is not to say that they are not stigmatized at all. I think that at present, even in these modern days, illegitimate children or non-marital children still suffer some stigma, but at the same time, there is a bit more openness about it. Perhaps from the sheer number of non-marital children that we have, there has to be some acceptance of them.
A Supreme Court ruling granting this petition would go a long way towards giving these children equal rights with the marital ones.
Yes, Your Honor.
I mentioned during my questionings with respect to Dean Cynthia about the Supreme Court of Japan Grand Bench ruling in 2013. Interestingly, that Saiko-san of Nippon did not hew to U.S. jurisprudence. They built their jurisprudence, their 2013 jurisprudence, based on their own societal standards. And number one standard was that public opinion is a factor. And secondly, that international law, where there is a modern trend towards giving equal rights to non-marital children, similar to what marital children have, was also factored in by the Saiko Saibanso of Japan. In our jurisprudence, we've applied the heightened security test when it comes to striking down discriminatory statutes.
Yes, Your Honor.
But in the United States, in fact, they apply a lesser, I believe, a lesser, or it's not as rigid as the strict scrutiny test that our court has applied in the past. This is the intermediate scrutiny test that the United States Supreme Court applied in Clark in 1988, much later than Llewellyn. And according to this test, it is enough that there is a substantial relation to the classification vis-a-vis a valid government objective. Now, in this case, is there any valid government objective if we uphold the constitutionality of Article 992?
Your Honor, I can only speculate based also on what was earlier decided in Diaz, the presumed enmity or antagonism between the legitimate and illegitimate lines in the family, that the government interest or government purpose for the behind this law is again to promote marriage as an institution and to protect the legitimate family relationships. But I think that if this is the state interest, that is a legitimate, in fact, an important state interest. But my problem, I would
Would
think,
there be a substantial relation
yes,
to
Your-
that government
no, there
objective?
wouldn't. There wouldn't,
There is
Your
none.
Honor. That's why,
Because
although,
we're talking about successional rights
Yes, Your
of a
Honor.
non-marital child. It has nothing to do with the marital status of the parent.
That's right, Your Honor.
Isn't it?
Yes, Your Honor. There is no substantial relationship, especially since if the reason for 992 is to show disapproval for illicit liaisons between adults, then the children that they may produce should not have to bear the burden of this unlawful act. So there is no substantial relation between, or there is no fit between the measure, between the law, and an avowed government interest, Your Honor.
I fully agree. You're proposing a dual approach to Article 992, and it is that either it is this court that strikes down
Yes, Your Honor.
this provision as, and I would like to use my own phrase, an obnoxious vestige of empire days as unconstitutional.
Yes,
Or
Your Honor.
we leave it up to Congress to come up with remedial legislation, which
Yes.
is the safer and prudent approach, do you think, Professor?
Well, Your Honor, I am...
Shall we take the road of judicial activism?
Your Honor, that will depend on the political orientation of the members of the court. The court, in a long line of cases, has done that, they have chosen, the members of the court have chosen to correct deficient legislation by, for instance, one that comes to mind right away would be, although it's not in my submission, for instance, the Molina case on psychological incapacity, where Article 36 is rather vague, and Molina instead identified 8 guidelines. No? So the court plugged in a huge gaping hole in the law, and it was based on these guidelines that several decisions of the court were based. But on the other hand, Your Honor, I likewise proffered the possibility of the court merely identifying that this is a law that is deficient at the very least, and therefore, as it did, for instance, in the People versus Henosa case, and I have a number of cases that I cited in my memorandum, that the court instead says that, well, there's something wrong with the law, or that all we have in the revised penal code is self-defense. The battered woman's syndrome doesn't appear in our revised penal code, and therefore Congress should pass a law. And we have to wait for Congress. And soon after, Congress did pass a law. So that depends, Your Honor, and I leave it to the wisdom of the court to decide which way. But what is clear to me, Your Honor, is that this law has to be changed.
Thank you so much for your presence and time, Professor.
Thank you, Your Honor.
Thank you, Mr. Chief Justice.
Are you through? Now it's already 5:20, late in the afternoon. Can we continue next Tuesday for the oral argument? Okay, what about do you have any comment on the resetting to Tuesday, next Tuesday? That will be September 10.
Chief, may I respectfully request for a September 17th
you will be out of
continuation?
it.
Because I will be on leave next week, Chief. I'd like to participate in the proceedings on September.
Okay, then we can agree on the 17th, September 17th.
Thank you,
That
Chief.
will be all right for the parties, no? you just adjust your schedule and then accept our proposal on the next hearing date, which is September 17, okay? So that will be all right? Okay, so there are no more other issues to be tackled this afternoon session. We suspend the session and then proceed to September 17 at 2 o'clock in the afternoon.
Please rise.
All rise. Please remain standing while the presiding Associate Justice and the Associate Justices of the Supreme Court leave the session hall.